Hello and welcome back to the Center for Critical and Cultural Theory. My name is Dr. Roger Green, and it's been a minute on the Intro to Critical Theory course, so my apologies to those of you who've been waiting out there. We're on to our last text for Intro to Critical Theory, and over the next couple of lectures, I'll sort of be wrapping up why I organized this introductory course in this particular way. So the text that we're dealing with here is Agamben State of Exception, and it's published in the early 2000s, around 2005 here by the University of Chicago. We're following up on several lectures that I gave over, or contextualized readings, as I call them, over Jacques Derrida's famous essay from the late 80s, Force of Law. And what you will be able to tell as we're reading the Agamben book is chapter two is titled Force of Law. And what I think is important, and why I think I've organized an introductory course to be ending with these folks, is obviously because part of what critical theory does, as I've been suggesting, is first of all, it's a critical theory of society. It always was from the beginnings of the Frankfurt School, way back to the first lectures, right? So we're trying to look at things at the social level. We have analyses that intersect various different disciplines, whether it's philosophy or economics, history, all sort of coming together. We've seen that there is a cultural shift among the critical theorists in the mid 20th century, right? So we don't want to just refer to critical theorists in the uncritical way that oftentimes right-wing people frame them as just simply a bunch of Marxists or leftists or something like that, because we know that even from the Frankfurt School thinkers early on, they're already seeing that obviously didn't get everything right, and that leads them in to an analysis of cultural production that's fruitful throughout the mid 20th century. And at the same time, we start getting the post-colonial uh, moments happening throughout Africa. So we saw some of that stuff with Fanon. If we were going to go on and do more advanced critical theory, that becomes the basis for an offshoot of critical theory called critical race theory, which has come up at various times in the class, and certainly is an ongoing phenomenon, even though I think that most of the ways that popular news media in the United States refers to critical race theory doesn't understand what it is. A basic tenet of it, of course, is that because we're looking at things in a at the level of society, which has always been the critical theory mechanism. The approach of critical race theorists has been to look at the ways that race and power are built in to the structures of society, and we could throw gender in there as well. So yeah, I think we could go on, and I have other lecture videos that are not part of the Intro to Critical Theory class, but I did decide to end the class on this question of sovereignty, and it's been with us throughout this class, from going back and looking at Lenin's theories of revolution in State and Revolution, and that kind of further leftist moment that we use to situate the German situation in which the Frankfurt School arises. And we've looked at Carl Schmitt in this class. And I think that, uh, uh, in some ways that people conceive of what critical theory is, they might have been surprised to see like an author like Carl Schmitt. The reason why we've looked at Carl Schmitt is uh, has a lot more to do with 21st century critical theory, right? And of course, in political theology, Carl Schmitt is theorizing the exception. And what we can see is in that kind of post-World War II moment through different thinkers, especially in Europe, they are already kind of returning to or carrying on a dialogue with Schmitt. It erupts in Telos Journal in the 1980s, which had traditionally been a leftist journal. The journal loses a lot of its subscribers when this discussion in the late 80s turns back towards uh, Carl Schmitt and to Carl Schmitt's interactions with Walter Benjamin, right? And so we see that although it wasn't in the Telos journal, the Derrida lecture slash essay form that we read it in for Force of Law was happening right in that particular moment. And if you're old enough to think back to that time, it's like the European Union is a thing that is being discussed in that moment, right? Um, like I can still remember going to Europe before the euro, but that's not that. I don't think for most of my students that's not the world that they have grown up in. In the early 2000s, in the way that Agamben opens this book, of course, we get the War on Terror, right? So in between 1989 and the early 2000s, we get the fall of the Soviet Union, the dot-com boom, this kind of big celebration of liberal democracy and capitalism. And then by the end of the 1990s and early 2000, we've already seen the rumblings with the first attack on the World Trade Center. But by the early 2000s, we get 9/11 and the increasing notion of a global war on terror, right? Which kind of shifts geopolitics from the Cold War situation of Russia versus the United States. It's not that that metaphor and that way of thinking has automatically leaves like overnight or something like that, because I think that we can look at later and ongoing positions in politics that are carryovers from Cold War style thinking. But with the post 9/11 moment and throughout the 21st century, what we do see are increasing moments that we might call states of exception. And they're often political moments. So, with the rise of right-wing politics, not just in the United States, but globally, right? We could look at the last 50 years with Francois Cousset's book, How the World Swung Right. So I think it's a longer sort of trajectory with the rise of neoliberalism, which is a big concept that we deal with in critical theory and that we dealt with in this class with Wendy Brown and with Glenn Sean Coulthard much earlier on in the semester. I still think that Wendy Brown is one of the sharpest critical theorists that we have today. Uh, just one person's opinion there, but I feel like her idea of the way that neoliberalism, even against its founders, like best of intentions, actually kind of paved a way for the opening of um, a right-wing takeover in liberal democracies, which is, of course, what if that's like the through line for critical theory, right? When Marcuse and Horkheimer and Adorno come to the United States, they're initially optimistic. But then they quickly see that liberal democracy in the United States can have its own sort of tendencies towards a totalitarian society. And they're all people who lived through it in Germany, right? So they might have seemed especially paranoiac or something. But when we look at the longer history of it now, we can see that there is kind of a through line, especially 100 years after the foundation of the Frankfurt School. We look at the rise of right-wing politics in especially Eastern Europe and South America. In Modi's India, we see authoritarian figures like Putin, um, who are in various sorts of discussions or negotiations with Donald Trump, who, if you thought it was a fluke the first time he was elected, he definitely got elected a second time. So, what is the appeal? What is the appeal of the shift towards the strong decider, authoritarian type of leader? And I think that that's where, at least for an intro class, where I've chosen to end things in this series of contextualized readings. So let's dig into Agamben, and Agamben is returning to Schmidt, and he's returning to Derrida, as we'll see more in chapter two. But this video is just going to be on chapter one, and he opens this chapter, "The State of Exception as a Paradigm of Government." Says the essential contiguity between the state of exception and sovereignty was established by Carl Schmitt in his book Political Theology, 1922. We had to read that earlier on so we can understand what a contemporary theorist like Agamben is doing. Although his famous definition of the sovereign as he who decides on the state of exception has been widely commented on and discussed, there is still no theory of the state of exception in public law, and jurists and theorists of public law seem to regard the problem more as a caestio facti than as a genuine juridical problem. Not only is such a theory deemed illegitimate by those authors who, following an ancient maxim according to which um, necessitas legem non habet, or necessity has no law, affirm that the state of necessity on which the exception is founded cannot have a juridical form, but it is difficult even to arrive at a definition of the term given its position at the limit between politics and law. Indeed, according to a widely held opinion, the state of exception constitutes a point, quote, point of imbalance between public law and political fact. So I'm not going to read the whole first paragraph here, but Agamben is situating um, this emergence of the question of sovereignty. That's going to be the resonating word. It's definitely part of what the Force of Law essay that we read. And it's an ongoing question, both in democratic politics and in further right-wing varieties of um, political governance. And I think Agamben is particularly, of course, interested in the relationship to law and a legal concept or a juridical concept of the state of exception and how is it theorized within constitutional forms of government. He says in paragraph two, it is this no man's land between the public law and political fact and between the juridical order and life that the present study seeks to investigate. Only the veil of covering the ambiguous zone is lifted, sorry, only if the veil of covering this ambiguous zone is lifted, will we be able to approach the understanding of the stakes involved in the difference or the supposed difference between political and the juridical, and between law and between and living being. And perhaps only then will it be possible to answer the question that never ceases to reverberate in the history of Western politics. What does it mean to act politically? That's a question he's adding. Remember back to Derrida's essay, Derrida was suggesting that if we take deconstruction seriously and we don't only think of it as a method of application to one particular text, right? But as a process that might have a more tentacular kind of arrangement into different modes of discourse, um, that we would be unraveling or destabilizing the very concept of law that grounds so-called Western civilization. Now, remember that, so like, sometimes people are like, oh, well, Jacques Derrida, he's more of this post-structuralist guy. He's not really like a critical theorist in the way that Horkheimer and Adorno are. But when we look back to Horkheimer and Adorno's book, like Dialectic of Enlightenment, for example, or we look back to Levinas, who again is also not thought of as a classic critical theorist, but who I threw into the course. We see this through line trajectory of critique, um, saying that there's something about modernity, there's something about Western politics and so-called Western civilization, even if we're going back to the Greeks or between the, you know, uh, mixing of Judaic and Greek thought, if we think about Derrida's essay, there is something of a through line that ends up in totalitarian orders, right? So Hitler for Levinas was the culmination of Western thought. Uh, for Horkheimer and Adorno, dialectic and of enlightenment, they saw Odysseus as the first bourgeois, if you think about the first chapter of that essay. Um, we see a bit of a different discourse with someone like Fanon, who is looking back before Marx, and this is why again, people if people just want to call Fanon a Marxian, a Marxist theorist or something, you have to like take into account that for Fanon, he's reaching more back to Hegel in some ways than he for his critiques than he is doing any kind of a strictly Marxian materialist critique, because what has happened is that there has to be an account for the psychological state of the colonized subject who might be different than the Marxian proletariat, right? Maybe closer to what Marx called the lumpen proletariat, but still not exactly like Marx had not been able to theorize the devastation, especially transgenerationally, that happens on colonized peoples. And so that's something that later thinkers, of course, like Fanon, like Albert Memmi, have contributed to this broader discourse of critical theory. So when Agamben says this at the end of 1.1 here, like the whole history of Western politics, he's asking this question, what does it mean to act politically? And he wants to hover. So he's taking a little bit of a different tact than Derrida, whose focus was on law, although they're going to mix in between here. There's going to be some deep meditation on thinkers like Aristotle and his politics, who lurk behind a text like this. I in my earlier Derrida lectures, I was connecting Derrida's point of a critique of legal thought in what so-called Western civilization to more recent critiques that I've done with my colleague Tink Tinker, who's a Washaje or Osage Nation thinker. And when we include indigenous critiques, which are more recent in critical theory, we're able to see a little bit more outside. It's not just a question of like Eurocentrism or critiquing Eurocentrism, although yeah, that's I guess part of it. But the idea of a particularly kind of Euro-Christian metaphysics that lurks behind the most seemingly secular ideas of the nation state, which of course has a Schmittian ring to it, right? Remember, if you back to political theology, Schmitt is the one who said that all significant uh, uh, political concepts are secularized theological ones. So, and Derrida, that the whole question about the messianic and divine law versus human law is all going to have this kind of ring going back to all the way back to Greek tragedy in some way to questions in Antigone, which Antigone is, of course, somebody that Hegel deals with heavily as he's formulating his kind of thinking about consciousness and is thinking about um, Geist or the phenomenology of spirit, right? Then the way that history moves way back into another text that, of course, we couldn't read in this particular intro class, but I'm laying out some other groundwork for places you might want to go. Uh, so. Agamben is definitely operating in this tradition of thought or thinking about the exception. And I think that he's building on Derrida, but he's thinking about um, the juridical and the political, the two types of zones, and how does this act on our daily lives. He says in 1.2 here, since then, the voluntary creation of a permanent state of emergency, though perhaps not declared in the technical sense, has become one of the essential practices of contemporary states, including so-called democratic ones. So we see, yes, the famous rise of Nazism and totalitarian projects, along with Italian fascism in the early 20th century, the devastation of the war of Weimar Germany and the Weimar Constitution. And then Benjamin had already kind of alluded to the fact that uh, we're seeing more and more states of exception being not no longer the exception, but the rule. And I think Agamben is definitely building right on top of that and saying, yes, this is true even in the early 21st century, is that even in so-called liberal democracies, what we see are these um, tendencies towards a permanent kind of state of exception. Agamben leaves us with several notes. He in his writing style here, he goes 1.1, 1.2, and then he'll have explanatory notes, which I find really helpful. And just as a writing strategy, I appreciate that that's something that Agamben does. So on page 3 of the text, the note after 1.2, he says the expression of global civil war appears in the same year in 1963 in both Hannah Arendt's On Revolution, which we read earlier. Now you can see how the class is sort of put together, and Carl Schmitt's Theory of the Partisan, which I didn't have you read Theory of the Partisan in this class. However, as we will see, the distinction between a quote real state of exception and a fictitious state of exception goes back to the French public law theory and was already clearly articulated in Theodore Reinach's book, De l'état de siège, études historiques et juridiques, or yes, the state of siege, studies in history and juridical thought, which is at the origins of the Schmittian and Benjaminian opposition between the real and the fictitious state of exception. Anglo-Saxon jurisprudence prefers to speak here of a fancied emergency. For their part, Nazi jurists spoke openly of um, gewollt, or a willed state of exception, for the sake of establishing the National Socialist state. And he'll say a lot more about the emergence of the Nazi Third Reich. In 1.3, moving on, the immediate biopolitical significance of the state of exception as the original structure in which law encompasses living beings by means of its own suspension emerges clearly in the military order issued by the President of the United States on November 13th, 2001, which authorized the quote indefinite detention and trial by military commissions, not to be confused with military tribunals provided for by the law of war of non-citizens suspected of involvement in terrorist activities. So that is, as the Agamben is writing this, that's the most immediate exigence, right? That's the political situation that he's thinking about, and he's thinking about detainees at places like Guantanamo Bay or even more so something like CIA black sites as well. And with this new emergence of this phenomenon called the global war on terror, how has this changed the ways that we have traditionally thought about the nation state and about issues of the contract or a social contract, and then of course issues the way that the idea of the contract might show up more tangibly a written constitution, which operates as a kind of contract. 1.4 goes on to talk about, he says that like the study is going to have to be broader than just thinking about Italian fascism or German totalitarianism or National Socialism. He says the present study will use the syntagma state of exception as the technical term for a consistent set of legal phenomenon that it seeks to define. This term, which is common in German theory, um, as a state of necessity is foreign to Italian and French theory, which prefer to speak of emergency decrees and state of siege, or social or fictitious état de siège fictif in Anglo-Saxon martial law and emergency powers avail. So he's looking at different linguistic and cultural traditions throughout Europe and the United States, right? So, uh, and again, he doesn't use this term Euro-Christian, but I'm thinking in the 2020s that a concept like Euro-Christian is more accurate for some of the things that Agamben is talking about, because we'll see later on in this chapter when he refers back to like a thinker like Gratian and like Roman Catholic canon law, things like that. We'll see that tendency, yeah, you could say like, oh, well, Agamben's an Italian thinker, and the Catholic Church is in Rome, and so it's more of a cultural presence for him. But I don't want to reduce Agamben to simply being an Italian thinker. I think that he's thinking about the formation of what becomes international law. That's where something like Guantanamo detainees might be being at least in some way publicly discussed as in somehow human rights law. Of course, they're not, as Agamben will tell us, they're not being legally defined as persons. So that's another issue there as well. But so for your own thinking, I've asked at various times in the course for people to think about whether or not the concept of Euro-Christian might be more useful to maintain the historical trajectory, whether we're talking about these legal formations here or whether we're talking about the political and governance assumptions that formulate early law in the United States and that also formulate concepts of modern concepts of race as well. Although that is not, of course, Agamben's project here. He says the state at the end of 1.4, the state of exception is the special, not a special kind of law, like the law of war. Rather, insofar as it is a suspension of the juridical order itself, it defines the law's threshold as a limit concept. In his note to that section, he says it's important not to forget that the modern state of exception is a creation of the democratic revolutionary tradition and not the absolutist one. I think that is a really interesting thing. When I've been thinking recently, I gave a talk at Matter Bookstore on the whether or not the left-right political metaphor, which is still very much how people in the United States that I talk to frame their thinking, of course, in terms of a two-party system, and which already leads to a kind of binarism, right? But um, I was giving a talk and tracing that left-right political metaphor back to the French Revolution as well. And I think that this is the thing that Agamben is giving us that's a little bit different than Schmidt too, because Schmidt wants to go directly to that idea of sovereignty. And so when Schmidt is talking in his book, he's really thinking about the early modern situation, right? He's thinking about thinkers like Thomas Hobbes, and less so someone like John Locke, who, of course, is the founder of the liberal tradition, but Carl Schmitt is not, doesn't have good feelings about the liberal tradition about what emerges as positive law within the liberal tradition. And so it would be someone more like Jean Baudin in France, and that theorizing sovereignty, and then someone like Hobbes, and then that relationship between um, some sort of divine revelation within the state, or at least the state's ability to decide on what scriptural interpretation might be, uh, leading someone like Hobbes to want a more fixed view or a set interpretation. Again, we could throw Spinoza in there as well. As an interesting thinker who I think the Euro Christians are definitely reacting to, right, as the Jewish thinker, uh, as well on that whole fascinating conversation in the early modern era, around what sovereignty is and how it emerges. The return in the 21st century to those thinkers is all part of this kind of tradition. So I'm gonna skip on here. So in the note, then he has a second note. So this is the second note to section 1.4. And he's talking about the fullness of powers. He's been locating, as I said a minute ago, uh, some of the thinking of the exception in the formation of the Enlightenment nation state project in France, especially. He says the presupposition here is that the state of exception entails a return to an original plurimatic state in which the distinction among the different powers, legislative, executive, etc., has not yet been produced. As we will see, the state of exception constitutes rather a kenomatic state, an emptiness of law, and the idea of an originary and indistinction of and fullness of power must be considered a legal mythology analogous to the state of nature. And it's not by chance that it was precisely Schmidt who had recourse to this mythology. In any case, the term full powers describes one of the executive power's possible modes of action during the state of exception, but it does not coincide with it. What he's getting at here, and it came up a little bit earlier on in the course, the whole idea of the theory of the state of nature, which goes again back to Hobbes and thinkers like him, although we can see it in Plato as far back as Plato. The idea that there's a kind of pre-political society that's a state of nature, even in Hobbes, Hobbes says that this is kind of a heuristic idea, right? This is maybe there wasn't an actual historical time, but we use it as a way to think of the so-called development of civilizational life. And I think that my indigenous colleagues rightly take issue with this because no matter how, so in the legal tradition, yes, I think that Hobbes says and maybe it wasn't always this way. This is like a model by which we might think about human societies, how human societies develop over time. And definitely by the time that we get to the Rawlsian veil, if like the most classic and most influential, at least even today, legal thinker in the United States, I think is John Rawls, who we have not read in this class, but who has a this concept of the veil of ignorance, and he thinks of it like the state of nature, like it's a way of getting us to think about how things might be hypothetically, and then what our decisions might be in that hypothetical situation. But the problem I think that my indigenous colleagues bring to this, and that irritates my liberal colleagues, is because they want to say, oh, well, it was always heuristic to begin with. It was never supposed to be like a part of nature. But it's like my indigenous colleagues, like all we need to do is look back to history and look at the ways that people like John Locke make claims, like in the second treatise on government, that in the beginning all the world was America without money. And so the civilization model and narratives that develop between the 17th and the 19th centuries that end up becoming the engines of genocide towards indigenous peoples um, uh, by referring to the idea of the state of nature as just this abstract hypothetical idea within the legal tradition, as if it didn't have real world effects on real people, right? That's a kind of evasion of the tangibility of material historical reality that is ongoing. For Glenn Sean Coulthard, if you remember back to his piece that we read, he takes even Marx to task for this because Marx has this idea of prior or primitive accumulation of capital. But uh, Coulthard is saying, like, first of all, we've got to throw in Hegel to correct Marx because Marx's materialist account still hasn't accounted for the psychological effects of colonialism. That's point number one. Point number two is that there's nothing post-colonial about actual indigenous people in contemporary society. It's not like there was this time period of the prior accumulation of capital, and that's when indigenous people were really being extracted from and enslaved and genocided. That process has continued as a through line from the beginning of European contact to the time that I'm making this video for indigenous peoples around the world for sure, but especially on the North and South American continents. And this is something that I, I can't stress enough in an intro to critical theory class because I think a lot of times people from this neoliberal kind of positioning where they are allergic to discourse about race and DEI and all of the stuff that's coming up in current day politics, they first of all, their anti-intellectualism will be like, oh, well, you can't even read it. You can't even understand what all these critical theorists are doing. Or it's just a bunch of old white men. It's like, well, it's not actually a bunch of old white men. And like a lot of the most creative and interesting critical theorists of the past 20 years have been people of color, but also more broadly, but also feminist theorists, and especially for me, indigenous theorists. So very, it's unsurprising to me that if people are trying to get rid of critical theory and through an anti-intellectual kind of claim to begin with, like the academic version of there's no such thing as society, which is Margaret Thatcher and Ronald Reagan's kind of neoliberalism put into practice. If there's no such thing as society, why have critical theory to begin with? Like we should just fire all these professors, get them out of here. They're just talking about they're just liberal elites or something like that. And that's not to say that there aren't like liberal elites out there in the world, but like not like the adjunct professor who's speaking to his computer from from a crappy apartment in Denver, Colorado, right? Like most of us who are actually out there teaching are adjuncts without health insurance who are living very precarious kind of lives, and we get assaulted from different all sorts of different angles on through this like anti-intellectualism, both from the right and the left, right? That there's just anti-intellectualism across the board. So the project of critical theory has always been one of struggle. Um, but I do think that for me, indigenous critical theory is some of the most important contemporary critical theory because it's able, through its own positioning, to direct insight not just towards Eurocentrism or towards the Euro-Christian kind of phenomenon, but to continuity over time. As Glenn Sean Coulthard says, like there was no the prior accumulation never ended. If we're going to have contemporary analyses, we've got to throw out that idea of periodic civilizational stages, and that's in Marx, but it's also in Adam Smith. All of the major Euro-Christian philosophers, moral philosophers or political philosophers, all start dealing with these kinds of civilizational stages in their theories in the years, unsurprisingly, after contact with indigenous peoples. And so the state of nature thing, I think, is more important. And I don't think it's quite on Agamben's map either, right? So I'm adding my own thoughts onto Agamben there. Um, in 1.5, Agamben says they are in let me just back up a sentence here from what I had marked. He's listed a number of books here about crises of democracy, crises of government. And he says while these books are quite varied and as a whole more dependent on Schmitt's theory than a first reading might suggest, they are nevertheless equally important because record for the first time how the democratic regimes were transformed by the gradual expansion of the executive's powers during the two world wars, and more generally by the state of exception that had accompanied the fall and followed the wars. They are, in some ways, heralds who announced what we today have clearly seen before our eyes, namely that since, quote, the state of exception has become the rule, it is not only appears increasingly as a technique of government rather than an exceptional measure, but it also lets its its own nature as the constitutive paradigm of juridical order come to light. So what he's doing here in this opening chapter, broadly speaking, if we're just looking at him as like a writer or an academic, right? Like he's saying, okay, Schmidt said all these things and they were important, but we've had, 80 years since the publication of Carl Schmitt's political theology. And we've seen all of these later jurists and legal theorists dealing with, in their own ways, the theory of the exception that goes back to Schmidt. And so he's just really just giving us a literature review, as we call it in academia, of what has been said. He oftentimes refers to Rossiter, and he gives a quote on page 9 here. In the atomic age upon which the world is now entering, the use of constitutional emergency powers may well become the rule rather than the exception. See, these are all people that are echoing the things that Walter Benjamin had already said, that the exception is becoming the rule. In describing, this is another quote, in describing the emergency powers of Western democracies, this book may have given the impression that such techniques of government as executive dictatorship, the delegation of legislative power, and lawmaking in administrative degree were purely transitory and temporary in nature. Such an impression would be distinctly misleading. The instruments of government depicted here as temporary crisis arrangements have, in some countries, and may eventually in all countries, become lasting peacetime institutions. This predilection, this is Agamben's, that was a long quote from Rossiter, but Agamben says, this predilection, which came 8 years after Benjamin's first formulation of the eighth thesis and this concept of history, was undoubtedly accurate, but the words that conclude Rossiter's book here sound even more grotesque. Quote, no sacrifice is too great for our democracy, least of all the temporary sacrifice of democracy itself. There's a chilling totalitarian edge to that kind of thought. So it's not just in these theorists like Walter Benjamin, or even of like a far or like a conservative Catholic theorist like Schmidt. It's people who are talking about theories of law, theories of the state throughout the century are making similar observations. Uh, and he says the first group um, of these thinkers of the exception belong to France, where the modern state of exception was born in the time of revolution. So he's locating it there. And Germany, he says, to the second belong Italy, Switzerland, England, and the United States. Scholarship is also correspondingly divided between writers who favor a constitutional or legislative provision for the state of exception and others, Carl Schmitt foremost among them, who unreservedly criticize the presence of regulating by law what by definition cannot be put into legal norms. In 1.7, he says the problem of the state of exception presents clear analogies to that of the right of resistance. It's been much debated, particularly during the constitution and constituent assemblies, whether the right of resistance should be included in the text of the Constitution. Uh, think back to Derrida's previous essay and the long discourse with Benjamin about strikers, right? And that the relationship between the general strike and the phenomenon of the state. What is the broader milieu or context in which the strike has even meaning? In on page 11 in the note, he says a brief history of he gives this is a long note, it goes several pages long, but he gives a brief history of the state of exception. And here again we drop back to France, and he says again that we've already seen how the state of siege had its origin in France during the Revolution. He then maneuvers on to talk about Napoleon's decree from December 24th, 1811, the idea of a suspension of the Constitution that happens. Um, then he goes to 1848, um, uh, in the establishing that the occasions, forms, and effects of the state of siege would be firmly set into law. Um, Napoleon III then had recourse several times to the law, and once installed in power, he transferred the Constitution of January 1852, the exclusive power transferred to transferred um, the exclusive power to proclaim a state of siege to the head of state rather than as parliament, right? So there's that kind of executive kind of power move that we see within the early couple of republics of France after the Revolution. And this is something that my American students need to sort of keep in mind is like we're on Republic 5, like despite the fact that the French Revolution and the American Revolution happened very close to each other, right? French politics have come into various constitutional crises. And in current news media and current discourse in the United States today, there's like we're hovering all the time around the idea of a constitutional crisis. The idea that the United States has lasted as long as it has without having a constitutional crisis of this order is rather impressive, except as what Agamben will let us know a little bit later on in the chapters that of course the American Civil War is a constitutional crisis. The outcome of that war, it just is quite different than what happens over in France. So it's interesting looking at French history because, like, from Agamben's perspective here, because he says, yeah, it's after Napoleon III transfers this from Parliament into an executive order that we then see the Franco-Prussian War and the insurrection of the Commune coinciding. So the general politics, like from Marx's perspective, when Marx looked at the Paris Commune, it leads him in the 1880s to speculate, like, well, maybe things are happening faster than I predicted that they were happening back when Ingalls and I wrote the Communist Manifesto. And in some ways, yeah, some things are happening faster and some things are not happening. And then, of course, he dies in 1883 before seeing the realization. But I think if we like, and so of course, like Marx is not talking about the state of exception as a theory, but when we look back historically from the discourse on the state of exception, we see that these movements towards totalitarian power that are going to shape the 20th century politics and geopolitics are definitely there as a through line in 19th century political changes that happen. So then he moves on to World War One and France, and looks at the state of exception France declared on August 2nd of 1914, and then walks through the between the wars in as he maneuvers on here, and then he says it can therefore. um, the end of the Fourth Republic in France is what he's getting at here. On April 10th, 1938, Edouard um, Daladier requested and obtained from Parliament exceptional powers to legislate by decree in order to cope with both the threat of Nazi Germany and the economic crisis. It can therefore be said that until the end of the Third Republic, the normal procedures of parliamentary democracy were in a state of suspension. When we study the birth of the so-called dictatorial regimes in Italy and Germany, it's important not to forget this concurrent process that transformed the democratic constitutions between the two world wars. Under the pressure of the paradigm of the state of exception, the entire political constitutional life of Western societies began gradually to assume a new form, which has perhaps only today in the early 2000s reached its full development. And we might say that, 20 plus years after this text, right, that it's become even more apparent, I think, in some ways, that what Agamben is saying here. But what we can't have, I think Agamben is saying, like, oh, like, well, this is like this phenomenon of the transfer towards a more concentrated executive power is only something that happens in the far right circumstances of Nazi Germany and fascist Italy. He's saying, no, when we really look at European styles of governance from the Enlightenment on, especially the French Revolution, we see that there's a through line of these tendencies towards the state of exception. And then of course, he'll shift his analysis in a few minutes here over to England. But so he's dealing really heavily with France, and that's partly because I think France goes through the shifts. So like the Third Republic falls, and then you have Pétain, the Pétainist government under the Nazis versus de Gaulle, right, and the French resistance. And that after World War II creates the Fourth Republic. And then there's another constitutional crisis with Algeria that um, Agamben refers to with respect to France in the early 1960s. And here he says de Gaulle had recourse to Article 16, even through the functioning of the public powers that had not been interrupted. Since that time, Article 16 has never been invoked, but in conformity with a continuing tendency in all of Western democracies, the declaration of the state of exception has gradually been replaced by an unprecedented generalization of the paradigm of security as the normal technique of government, right? And that has echoes definitely like to Michel Foucault and the security state and security territory property and governmentality and all of the other ideas that came up in the course as well here. He then shifts over to Germany and this question of Article 48 from the Weimar Constitution, which we could think about in different ways. Like, in one kind of logic, it should be the logic that would have prevented Hitler from coming into power because it allows the state to protect itself. But there's also like kind of a weakness or a loophole sort of built into it. And Agamben notes that Carl Schmitt in 1925 says that Article 48, um, uh, with reference to Article 48, no constitution on earth had so easily legalized a coup d'etat as did the Weimar Constitution. So Schmitt says that in 1925. I mean, he ends up being right, by as we will see, not even by 33 with Hitler, but by 1930. Um, on several occasions, particularly in October of 1923, the government had recourse to Article 48 to cope with the fall of the mark, economic fall of the mark, right? And the confirming the modern democracy to conflate political, military, and economic crises. He says it was well known that the last years of the Weimar Republic passed entirely under the regime of the state of exception. It's less obvious, he says here, to note that Hitler could probably not have taken power had the country not been under a regime of presidential dictatorship for nearly 3 years and had parliament been functioning. He says in July 1930, the Brüning government was put into the minority, but Brüning did not resign. And then instead, he says President Hindenburg granted him recourse to Article 48 and dissolved the Reichstag. So from in Agamben's reading here, and I think that this is important, and I think Agamben's right here. From that moment on, Germany in fact ceased to be a parliamentary republic. So there's like this stage between 1930 and 33 where the government just really isn't working as a parliament, and it's working as this kind of um, uh, dictatorship to begin with, and then it's from that moment that we get uh, Hitler coming in after Hindenburg's death and declaring himself Supreme Chancellor, and then immediately declaring a state of emergency that lasts until the end of World War II. Then Agamben goes over to Switzerland. We just have one brief paragraph, but it's Switzerland as unusual, as you, if you ask me. Swiss politics are tend to be quite conservative, and but for not being an active war state, what I think what Agamben is saying here is that it's quite interesting how dictatorial the Swiss situation can be. Then he switches over to Italy. In the middle of the Italy section on page 17 of the text, he says in 1926, the fascist regime had a law issued that expressly regulated the matter of law decrees. Article 3 of this law established that upon deliberation and Council of Ministers, quote, norms having force of law could be issued by royal decree. One, when the government is delegated to do so by a law within the limits of the delegation, and two, in extraordinary situations in which it is required for reasons of urgent and absolute necessity. The judgment concerning necessity and urgency is not subject to any oversight other than the Parliament's political oversight. And so this is something that Agamben keeps coming back to, even when he starts to talk about the US Constitution a few pages later. It's like, well, you might have this like this kind of language about like what happens in an exceptional times, but there isn't really much discussion of how and who decides in those particular times. Now, Schmidt solves that problem because he says that the sovereign is the one who decides in the state of exception. But that is much less clear in a liberal democracy, which is why Schmidt thinks that, and the right wingers think that it doesn't really work. We go over to England and the idea of martial law on page 18 here. Um, he says, thus Schmidt sought to distinguish martial law from military tribunals in the summary of proceedings that at first applied only to soldiers in order to conceive of it as a purely factual proceeding and to draw it closer to the state of exception. Quote, despite the name it bears, martial law is neither a right nor a law in this sense, but rather a proceeding guided essentially by the necessity of achieving a certain end. Yeah, I think that there's a way that we could maybe think about that with a state of exception like Hurricane Katrina, or pick your environmental disaster that might be more recent. But the relationships with FEMA, which is now being dismantled in current times, but uh, declaring martial law because, there's just been like a horrific environmental event, and things need to be figured out for that specific period of time. That's more specific than I think that what Schmidt is saying is more specific than what we're really meaning by the state of exception. Although I think that, from the 21st century perspective, we see the whole discourse about the environment and increasing instances of environmental devastation that have been brought on by uh, human industrialized society, sometimes called the Anthropocene, but I followed Jonathan Moore. It's the Capitalocene. It's not just humans in general. It's a very like small population of humans that really construct industrial society, and then that benefit from it and continue to benefit from it. today. And even if you disagree with me there, it just seems like the more uh, the 21st century goes on, the more we're seeing these environmental crises that can't maybe be as easily divorced from politics in the way that somebody like Schmidt might have thought about it. Page 19, he goes over into the US and he says the place um, both logical and pragmatic of the theory of the state of exception in the American Constitution is in the dialectic between the powers of the president and those of Congress. This dialectic has taken shape historically and in an exemplary way, already beginning with the Civil War, as a conflict over supreme authority in the emergency situation, or in the Schmittian terms, and this is surely significant in a country considered to be the cradle of democracy, as a conflict over sovereign decision. And so this takes them into an analysis of Abraham Lincoln and the emancipation of slaves. And Agamben, I think, is correct here to say that this is clearly an example of the state of exception. He refers to Article 1 of the Constitution, and the privilege of the writ of habeas corpus shall not be suspended unless when in the cases of rebellion or invasion the public safety may require it. So that's that instance of like, yes, there there might be times when the law needs to be suspended for some sort of reason, but we don't really get how and why or who makes the decision for when that actually happens. Although we do get in the same part of the Constitution, we get that Congress is the one who gets to uh, declare war, but then the president is the commander in chief of the military. And the back and forth there between the executive and legislative branches in the United States ends up being ambiguous enough that someone like Lincoln comes in and takes advantage and says that there was a moral reason for this, or I knew that there was broad popular and cultural support for the thing that I was doing, and I suspended the law in order to preserve the United States itself with the Civil War as well. So that's all on page 20 there. And I think that that's something that, that is deeply part of American discourse. I'm currently teaching a US history course, which is why I've been prevented from finishing my videos on the theory course because I've been steeped in US history. Uh, we get, of course, after the Whig party politics, and this is going way deeper than Agamben's going here. We get this the Whig party politics, Whig party versus the Jacksonian Democrats, or the Jeffersonian Democrats, as we might call them. That is kind of dealing with this issue of slavery from the Missouri Compromise back in 1820 all the way into um, the Kansas-Nebraska Act in 1854, and uh, various questions of slavery and citizenship that are going on, that creates this crisis, and then it's there at the foundation of the country if you're reading the Constitution, but then becomes different interpretations of the Constitution itself. But there is no doubt in my mind. I think Ogaman is exactly right that we want to think that Lincoln invokes the state of exception, but in the same way, like as a kind of prelude to what's going to happen in the 20th century, like Lincoln is like ahead of the game there. We see it again in Wilson at the end of World War One here on page 21, and then in FDR. So in the 1930s, although Agamben says like yes, Congress and Wilson and FDR are a little bit different than Lincoln in the sense that they are more attentive to working with Congress, and then Congress is granting them these more executive powers in order, under FDR's case, for example, to uh, uh, make quick decisions regarding the economic crisis of the Great Depression, whereas Lincoln didn't seek that. Lincoln kind of assumes that he's going to have this broad support, but doesn't seek it beforehand. And so a point here is just that we can't think of this in terms of like just like right or left politics, whatever you might think that well, Abraham Lincoln morally did the right thing. But when we look into Lincoln, he wasn't that progressive. Like he was a proponent of the Back to Africa movement, not the Marcus Garvey, but an earlier version of what was called colonization, which was to free black people, the slaves, but then ship them out of the country because they were going to be a political problem. Of course, the free black people in the United States, like Frederick Douglass, had to go and talk to Lincoln and say like, look, we're not leaving the country, and you should be um uh thinking about this in a different way. You should be thinking of us as citizens, right? So of course, after the Civil War, we get the 1866 Civil Rights Act that paves the way for, of course, the 13th, 14th, and 15th Amendments of the U.S. Constitution. This is not an Agamben. This is just me because I've been teaching this lately. You see, 1866 Civil Rights Act grants birthright citizenship. 13th Amendment makes slavery illegal. 14th Amendment is equal protection for people regardless of their previous state, and also that birthright citizenship issue. And then, of course, 15th Amendment is for Black men to get the right to vote. And so when we're looking at current day attacks from the current White House under Trump 2.0, um, the attacks on birthright citizenship from a historical legal perspective, even though they're framed against illegal immigrants today, the real sort of area of attack, if the current regime is attacking the 1866 Civil Rights Act on birthright citizenship, there, it's actually the legal precedent that then allows for 14th Amendment and equal protection. And then that equal protection stuff is what's going to grant voting rights and citizenship to all sorts of people eventually, not right away, because 15th Amendment happens, but then eventually we get Asian Americans. So, like we get the striking down of race laws. We get women's right to vote in 1920, right? So there's this whole sort of series of legal processes that can be done away with, and it's under equal protection that we might think of about something like abortion and abortion rights. All of the DEI disability stuff is like all going back to the 14th Amendment and equal protection. And so the attack on birthright citizenship is a way to dismantle all of that, and also to go back to an earlier notion of what the US was before the Civil War, or what some people in current right-wing politics have sometimes referred to as constitutional originalists, and that kind of perspective. What Agamben doesn't talk about here, while I'm thinking about it, is the recent statement by controversial statement by Vice President J.D. Vance, where Vance echoed Andrew Jackson's call out to John Marshall. And this is going to come back to Agamben, something that I'm going to critique Agamben a little bit here. John Marshall is the head of the Supreme Court during the 19 or the early 1800s, 19th century, and he really is the brains behind getting the Supreme Court to be the powerful institution that it comes to be. And in a series of cases, sometimes called the Johnson Trilogy, Johnson versus McIntosh, I have other lectures about this on the critical theory site. And then Worcester versus Georgia and Cherokee versus Georgia. There are three cases called the Johnson Trilogy that eventually create the legal thinking about how Native Americans are dealt with in this country, about federal Indian law or this new apparatus of law called federal Indian law. Remember, Indian relationships from the Constitution and during this period are being dealt with in terms of Congress and treaties. So it's international relations is the way that relationships with Indians, and I'm using that term from the period, right? Like you want some people might want to clean up like Native American or something like that, but we want to be careful because when lawyers know that you've changed terminology, then they can be manipulative and say like, oh, well, we weren't talking about that, we were talking about this. So we have to use the historical terminology as it's used in the Constitution and the Declaration of Independence, which calls natives savages after women and children, right? Which is really for Thomas Jefferson to get colonists on board because the colonists have been wanting to move west into Indian territory, but under the Royal Proclamation from Britain, uh, uh, King George had stopped colonists from being able to move west. So that's part of the motivation for the American Revolution. Again, I shouldn't. It's a different lecture. It's a whole other course. But um, how the early U.S. government is thinking about Indians is super important for for this stuff. So, long story short, you probably learned sometime in your life about the Trail of Tears or Cherokee removal. It's not the only people being removed by any means, but it's the most egregious case. And the reason why it shows up so much in American thought, as being this devastating moment is because the Supreme Court, by the end of the trilogy of cases, actually says that Georgia doesn't have the right to remove the citizens or the Indians, the Cherokee. Um, uh, and the kind of perhaps apocryphal uh, language used by Andrew Jackson, who's president at the time, is that if John Marshall wants to stop the removal, John Marshall can use uh, get his own army and prevent us from doing it. And what he's doing there is he's saying, I'm invoking my executive privilege as the commander in chief of the United States, and I'm going to forcibly remove Indian people, even though the judicial branch of the government has said that this is an illegal thing to do. Vice President Vance last month echoed Andrew Jackson that statement with regard to current relationships, but as something a good thing, right? That like the courts don't really matter as much is the sentiment that's coming out there. And so I think that this is, an unfolding event. So agree with me or disagree with me, but I think that both Agamben leaves out of his own analysis um, and the thing that's really driving like towards perhaps a constitutional crisis right now in the United States, which is the balance of powers, not just between Congress and the executive branch, between Congress and the president, but in the whole judicial branch too of the Supreme Court and federal courts and the way that charges of weaponization of the legal system are going back and forth across Democratic and Republican Party lines in recent politics in the United States. This is all um, stuff that for all of Giorgio Agamben's attention to juridical stuff, he doesn't give any attention to the U.S. judicial branch. He always is talking about Congress uh, versus the executive office. So just a minor critique. I think Agamben, of course I have a lot of respect, but that my United States perspective maybe is coming in a bit there. And he maneuvers through FDR. It's not a right or left thing or a Democrat or Republican thing. This tendency towards the consolidation of executive power. He moves on page 22, and he's quoting Rossiter again here to through World War II, and he talks about like Japanese internment, which I do think that's a clear case of this state of exception is like the annihilation of people's rights in a completely racialized move. which I think is important. And then again, this is small critique, but you can't do everything in a book. But he jumps straight from World War II to and not or internment of Japanese Americans to President Bush's decision to refer to himself constantly as the commander-in-chief of the army after September 11th, 2001 must be considered in the context of this presidential claim to sovereign powers in emergency situations. If, as we have seen, the assumptions of this title entails a direct reference to the state of exception, then Bush is attempting to produce a situation in which the emergency becomes the rule and the very distinction between the peace and war and between foreign and civil war becomes impossible. I don't have a problem with that statement about that's a way to read what Bush's decision was or Bush Jr.'s decision at the time. Um, but it's just this leap. I mean, because if you think about US politics, like there's a lot that happens like in the 1960s, for example. There's a lot that happens with Nixon, for example, that might be really relevant to this discussion of states of exception. I mean Reagan, Iran-Contra, like there's a lot to be there's just a lot to be said. And also and probably, maybe I should invoke Wendy Brown here. What he doesn't give an account for is the rise of neoliberalism itself. Like, there's none of that in Agamben's analysis here. Uh, um, and that's a problem, I think, for because it's a big piece that is left out of how we are currently theorizing and thinking about the situation, right? But he leaves the economic out analysis out there. So, okay. Um, on to section 1.8. Uh, he is now just walking through different theorists who have different takes on what the state of exception might be. Among one group, one camp, he might say, um, some understand the state of exception to be an integral part of positive law because the necessity that it grounds it acts as an autonomous source of law, while others conceive of it as the state's subjective, natural, or constitutional right to its own preservation. In truth, skipping down a couple paragraphs, in truth, the state of exception is neither external nor internal to the juridical order, and the problem of defining it concerns precisely the threshold or zone of indifference, wherein inside and outside do not exclude each other, but rather blur with each other. That's a kind of logic, topographical way of see, like he's saying that yes, well, you have one camp that thinks this way and one camp that thinks of another way. We need to do a deeper analysis, shows us more of the aporia, the puzzle, or the paradox that's involved here with what state of exception is. Returns to the idea of necessity has no law in section 1.9. Or necessity um, does not recognize any law versus the interpretation that necessity creates its own law. He says further down the page, after having stated that sacrifice must be offered on the altar of consecrated politics, Gratian, he's returned. So again, this is where he returns to this Roman canon law theorist, right? Gratian adds, quote, "It's preferable not to sing or listen to uh, the Mass than to celebrate it in places where it should not be celebrated. It's preferable not to sing or listen to the Mass than to celebrate it in places where it should not be celebrated, unless it happens because of a supreme necessity, for necessity has no law. More than rendering the illicit licit, necessity acts here, says Agamben, to justly or to justify a single specific case of transgression by means of an exception. Now, I think that there's something really interesting and pregnant because I've already suggested that indigenous critical theory is where I think a big fruitful part of our discussion is. It's like not that you have to be indigenous in order to do it. The problem is that non-indigenous people don't read indigenous people's thought, or they relegate the thought to identity politics, which are like or this kind of us them kind of thinking that's fueled by neoliberal marketized ideas about identity. But if you take indigenous critique seriously, there's a lot more to be said here, and there's a lot more to be said about a thinker like Gracian and the way that that kind of foundational legal thinking is going to show up in issues like doctrine of discovery, which I have several lectures on in my critical theory courses as well here. Um, so more than Agamben can cover in his book when it comes to that issue. I also just think that he doesn't have indigenous people on his map as a theorist. He just doesn't. Um, over on page 25, um, he says, what is at issue here is clearly not a status or a situation of the juridical order, such as the state of exception or necessity. Rather, in each instance, it is a question of the particular case in which the strength and the ratio, or the strength and the reason, force and reason of the law find no application. And in his note to that section, he says, he's gone back to medieval times, right, with Gratian, and he says that in this sense, the medieval exception represents an opening of the juridical system to an external fact, a sort of fictio legis, by which, in this case, one acts as if the bishop had been legitimately elected. The modern state of exception is instead an attempt to include the exception itself within the juridical order by creating a zone of indistinction in which the fact and law coincide. That's exactly what a Catholic conservative theorist like Schmidt says is horrible about modern forms of so-called secular states. That if you don't have that idea of the strong sovereign as being attached to this um, sovereign that has some sort of access to divine power, then you have uh, the the problem of liberalism, which is the problem of only a positivistic sense of law, and what happens to hold things together when the law must be suspended. For Schmidt, the law can be suspended because the sovereign is the one who decides on the state of exception. So the state doesn't become destroyed when the legal system is put into suspension because the state exists in the body of the sovereign decider. Um, but no decision can be made in that kind of state of exception from a democratic order where everybody would just be voting because votes take rules and regulations, and if the rules and regulations are all put into suspension, then there's nothing to hold it together anymore, and so the system eats itself. That is the right wing Schmittian critique of liberal democracy. He interestingly just returns to the idea of Antigone and laws that are sort of deeper than human laws. So he's going back to ancient times there, to Greek tragedy. I think that's important, and I also think it's important that Antigone in that same instance is going to be the main figure that Hegel uses in his phenomenology of spirit to think about how history moves and chthonic gods and what is owed to the gods and what is owed to humans. He doesn't expand on that. Agamben doesn't, but of course, I think that back to Derrida's force of law, that definitely shows up in Derrida. On page 29, he says the essential point in any case is that a threshold of undecidability is produced at which the factum and the use fade into each other. What has happened and what is right, what is law and what is actual instance, how do they, when they bleed into each other, we get this threshold moment. And that thinking of the threshold moment is what he thinks that the theory of the exception has to take into account in a richer way than theorists have have thought about it before. On page 30, he says that, let me start at the beginning of that sentence. This naive conception, which presupposes a pure factuality that the conception itself is called into question, is easily critiqued by those jurists who show that far from occurring as an objective given, necessity clearly entails a subjective judgment, and that obviously the one circumstances, the only circumstances that are necessary and objective are the ones that are declared to be so. On page 30, he gives a long um, uh, citation of Ballador and Pagliari there. And then he says the attempt to resolve the state of exception into the state of necessity thus runs up against as many and even more serious aporias or puzzles of the phenomenon that should have to be explained. Not only does necessity ultimately come down to it's to a decision, but that on which it decides is, in truth, something undecidable in fact and in law. Then he has the note and he basically says about Schmidt what I just said a few minutes ago. Schmidt sees the state of exception as precisely the moment in which the state and the law reveal their irreducible difference. In the state of exception, the state continues to exist while the law recedes, says Schmidt. And thus he can ground the extreme figure of the state of exception in the sovereign dictator um, as having the constituent or constitutive power, constituting power. Um, he ends here in section 111 with a return again to Napoleonic code. And he says, in the majority of modern legal systems, the judge is obligated to pronounce a judgment, even in the presence of a lacunae or a gap in the law. And so what he's getting at here is that there's something about legal systems, like even if the judge knows that like there isn't really a good answer, the judge has to act itself. Um, and whether the act is constitutive or we conceive of it as an interpretation, it's the act that keeps the apparatus of law still in play. Far from being a response to a normative lacuna, the state of exception appears as the opening of a fictitious lacuna in the order for this purpose of safeguarding the existence of the norm and its applicability to the normal situation. The lacuna is not within the law, but concerns a relation to reality, the very possibility of its application. It is as if the juridical order contained an essential fracture between the position of the norm and its application, in which, in extreme situations, can be filled only by means of a state of exception, that is, by creating a zone in which the application is suspended, but the law as such remains in force. That takes us to the end of chapter one. I went into some American history stuff in this contextualized reading. And to also just I'm wrapping up the Intro to Critical Theory course here, and wanting those of you who are watching who have made it all the way through the course to see why I've structured things as an intro in this way. It's to really to give those of you who are interested in this discourse of critical theory a way into like what is at stake in current critical theory in the 2020s. And of course, there are, you know, so many thinkers that I've never not been able to talk about or issues that I haven't talked about, but it seems to be one of the most present issues in the 21st century has been the ideas of the exception or state of exception alongside a massive resurgence of right-wing uh, movements and right-wing uh, governments being in play, tendencies towards strong deciders. And I think that even if we were looking at American politics, whether we're talking about a Democratic president or a Republican president, I think that there's been a kind of dialectic between both of those, the two majority, or the two mainstream parties anyway, that have worked together throughout the 20th century. Although we could go back to Clinton for sure in the 1990s and Clinton's embrace of neoliberalism, where the so-called left is really enabling the right's uh, formation of a militarized police, where the protests that happen on one side end up justifying the law and order politics that then come in and risk taking away our ability to protest. Where we see like a flip of like the 1960s situation where you have like massive protests on Washington. You have the levitation of the Pentagon in 68, where we see activism as being associated with progressive or leftist politics, all of a sudden becomes the so-called insurrection, depending on who media and media is what terms they're using, right? The insurrection of the Capitol on January 6th, a few years ago. That there's so much more to be said about that, and I'll maybe mention a few other later books as we end the course. But I'm going to stop this video here and then maybe do one or two more videos on the rest of Agamben, and then send you all on your way. So thank you for, as always, for listening, watching, whenever, wherever you are.